Hi, my name is Andrew Meinzer of Meinzer Law Firm PC. Today I'm going to talk with you about how to manage a vacant family house when you are managing the affairs of another person in California through a trust, probate decedent estate court proceeding, or conservatorship court proceeding. I'm not going to explain in this video what these proceedings are all about. We've published many videos here that explain them in detail. This is the first video of a two-part video series. In this video, we'll provide you with rules and information. In the second video, we'll demonstrate how those rules apply to a set of real-world facts. What we're discussing here is what I call the vacant home dilemma, and it can get you into trouble if you're not careful. It arises all the time, and most often in the context of a trust. So we'll concentrate on the trust context here. The trustee of a trust, that's the person in charge of carrying out the trust terms, has a duty to preserve property of the trust estate. Those are the assets and finances, and a duty to make that property productive. The trustee may hold a reasonable amount of funds necessary to pay trust estate obligations and other obligations. Otherwise, the trustee must hold all trust assets in a way that is safe and that also generates income, dividends, and/or increase of value as a reasonably prudent investor would do. The real property of the trust estate cannot remain vacant and unrented for a sustained period of time. Rather, it must be rented or it must be sold and the net sale proceeds invested. Otherwise, the trustee may be violating his trustee duty to make a trust estate property productive. Also, the trustee of a trust has a duty to treat all trust beneficiaries impartially. The trustee must act impartially with respect to investing and managing trust estate assets, accounting for any differing interests of the beneficiaries. This means that the trustee cannot allow one beneficiary to live in a parcel of real estate of the trust rent-free and to the exclusion of all other trust beneficiaries. Now, all of this seems to make sense for most people regarding assets other than the family house. For some reason, people often fail to realize that these rules also apply to the family house. Perhaps they don't think of the family house as something to use to generate income because mom and dad, and perhaps all the children, lived in it for so long without paying rent. Now, no trust police exists in California, and generally no government agencies are randomly investigating trusts to ensure that the trustees are keeping the trust productive. But family members and others close to the situation may be paying attention, and at some point one of them may bring this issue to the court's attention. There's no bright line rule about how much time is too much time. It depends on the unique factors of each case. Courts consider this issue on a case-by-case basis. Allowing the family house to remain vacant and unrented for 36 months is likely too long. 6 to 12 months is less risky. The vacant house dilemma is only one of many things that can get the trustee of a trust, a conservator of a conservatorship court proceeding, and an administrator or executor of a probate decedent estate court proceeding into trouble. Don't risk personal liability by making this type of mistake. Hiring an attorney experienced with trusts, conservatorship court proceedings, and probate decedent estate court proceedings can keep you out of trouble. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in trust cases, conservatorship court proceedings, and probate decedent estate court proceedings. Contact Meinzer Law Firm PC to assist you. Again, the next video will demonstrate how these rules apply to a set of real-world facts.